were transmitted from the polling stations and accompanied by the scanned image of Form 34A, contrary to the provisions of Section 39(1)(c) of the Elections Act as read together with Sections 44 and 44A of the Act. In response, the first respondent submitted that the difference in the results announced on the forms and the public web portal did not offend any law or regulation in view of the fact that the results in the forms were final, while the results on the public web portal were only statistics. Mr. Nyamodi, counsel for the first respondent, also submitted that in view of the Court of Appeal's decision in Minor Kiai, the system of transmission had to be reconfigured to allow for manual transmission. Counsel explained that the source document that the first respondent relied on to do so was no longer Form 34A, but Form 34B. Likewise, counsel submitted a similar fate had befallen Form 34C in terms of format and structure. Towards this end, counsel informed the court that the original Form 34C, which had contained a Form 34A tally, was reconfigured by the first respondent to exclude that tally so as to conform to the decision in the appellate court case in Minor Kiai. As for the controversy surrounding the electronic transmission of results, counsel submitted that such transmission was a mere conveyance belt and nothing more. To this, Mr. Ngatia, counsel for the third respondent, would later add that the electronic transmission with which the petitioner was obsessed was like a matatu and no more. What was important, counsel urged, was what was conveyed, meaning the results, as opposed to the manner in which it was conveyed, meaning the electronic transmission. The first respondent also submitted that the security features of the Kenya Integrated Electoral Management System was programmed to capture and transmit only one image. In some instances, text data was transmitted instead of the filled and scanned Forms 34A. At any rate, argued the first respondent, the omission of untransmitted forms was cured transmission of results. The petitioners highlighted various discrepancies. For instance, that there was transmission of results from slightly more than 11,000 official closing time for all polling stations. In addition, the petitioners questioned the streaming of results in constant percentages of 54% and 44% in favor of the third respondent and the first petitioner, respectively. The petitioners further claimed that there were numerous discrepancies between the results declared in Forms 34A and those in Forms 34B from various polling stations across the country, contrary to have conjured in our minds a puzzle of labyrinthine proportions regarding Forms 34A. In the face of a very clear and unambiguous Section 39(1)(c) of the Elections Act, what went wrong with this critical document? The case for the petitioners is that the second respondent, in exercise of his responsibility as the returning officer of the presidential election, declared the results for the election of president before receiving all the Forms 34A from the 40,883 polling stations from across the country. Incomplete results, argued Mr. Otiende Amolo for the petitioners, could not be a basis for a valid declaration. The respondent's answer to that assertion is that the results were declared on the basis of Forms 34B, all of which had been received by the time of the declaration, was made. In an affidavit sworn by Koitameto Lekina in support of the petition, there is telling correspondence which we had referred to earlier, but which we reproduce in the present context. On the 10th of August 2017, the deponent, acting on behalf of the petitioners, wrote to the second respondent in the court. Your brief on the above subject at Bomas on the 10th August 2017 at around 9 p.m. refers. You informed Kenyans that, and the world at large, that IEBC had received over 40,000 Forms 34A and about 170 Forms 34B. We have requested IEBC for all these forms for purposes of verification. Members of your secretariat have informed us that they cannot avail 29,000 Forms 34A as at 11 p.m. of 10th August 2017. We kindly request the Commission expedite release of the remaining Forms 34A and B to enable us complete the verification exercise, unquote. Again, on the 14th of August 2017, the deponent wrote, quote, this is a follow-up on our letter dated the 10th of August 2017. Until now, IEBC has only furnished NASA with 29,000 Forms 34A and 108 Forms 34B. We urgently require the unsupplied 10,000 Forms 34A and 187 Forms 34B to complete the list of documents the Commission was supposed to release to all the candidates in the just concluded general elections. Attached, please find a list of the outstanding 187 constituencies for your immediate action, unquote. On the 14th of August 2017, the Secretary and CEO of the first respondent wrote as follows. Reference is made to your letter dated the 14th August 2017 requesting to be supplied with the remaining forms that were not supplied earlier. The Commission is in a position to provide all the required Forms 34B immediately. We are, however, not able to supply Forms 34A as at the moment, but the same shall be availed to you as soon as possible. It is a fact that the correspondence quoted above did take place, and the contents of the said correspondence were never controverted. On this basis, a number of questions therefore arise. A, why was the first respondent not able to immediately supply the petitioner's agents with all the forms 34B upon declaration of results if, as it was submitted, the said results were based on the same and all of which were said to have been availed? B, why was the first respondent not able to supply all the forms 34A said to be around 11,000 to the petitioners at 14th August 2017, 4 days after the declaration of the results? C, were all the scanned copies of forms 34A electronically transmitted to the National Tallying Center simultaneously with those transmitted to the constituency Tallying Center in accordance with Section 39(1)(c) of the Elections Act? If so, why would it have been impossible for the first respondent to avail those copies to the petitioners? If not, why were they not transmitted in the manner required by the law? We sought answers to these questions as we listened to the submissions of counsel on the emerging conundrum. The submissions of Mr. Nyamodi on behalf of the first respondent made disturbing, if not startling, revelations. According to counsel, the first respondent used forms 34B as opposed to forms 34A to declare the final results of the presidential election. He emphasized that at the time the final results of the presidential election were declared, all forms 34B had been collated. It was counsel's submission that the declaration of sections 39, 2, and 3 of the Elections Act 2011 by the Court of Appeal as being inconsistent with the Constitution curtailed the first respondent's ability to change, amend, or alter the results transmitted from the constituency. According to him, therefore, the decision of the Court of Appeal in the minor KI case extinguished the concept of provisional results. Consequently, the numbers manually entered into the KEMS did at the close of polling and transmitted simultaneous to the CTC and the NTC bore no status in law. They were mere statistics, although, as Mr. Muhati stated in his affidavit, the presiding officer had to show the agents present the entries made for confirmation before transmission. Mr. Nyamodi further explained that the completion of the transmission of the images and 4G, 3G, and 4G network coverage. In respect of areas lacking 3G and 4G network coverage, the respondents established alternative mechanisms to ensure completion in transmission of the image of the Form 34A. The procedure adopted in the transmission and tallying of results of the presidential election was in conformity with the decision of the Court of Appeal in the minor KI case. On the basis of this process, counsel submitted that the petitioner's allegation that the first respondent deliberately predetermined and set itself on a path of subverting the law by being a law unto itself was unfounded. In addition, Council submitted that the determination by the Court of Appeal on the finality of presidential election results declared by the constituency returning officer also changed the structure of Form 34C. Regulation 37, Subregulation 3B, for avoidance of doubt, provides as I now read. Upon receipt of Form 34A from the constituency returning officers under Subregulation 1, the chairperson of the commission shall tally and complete Form 34C. However, the first respondent had to allegedly modify Form 34C to reflect the entry of Forms 34B, which was the form declared by the Court of Appeal to be the source document to determine the winner of a presidential election instead of Forms 34A. Mr. Nyamodi concluded by reaffirming that the way the first respondent structured its transmission system was largely based on the Court of Appeal's decision in the minor KI case, which did not interfere with or negate the will of the people resident in Form 34A. What was Mr. Nyamodi saying? We were left to ask. Was Council admitting that the second respondent indeed, as claimed by the petitioners, had declared the presidential results without having received all Forms 34A? Was he in the same vein also admitting that not all Forms 34A had been electronically transmitted to the National Tallying Center from the polling centers as required by law? Where did the language of statistics as opposed to results emerge from? Was Council disclosing the fact that fundamental changes had been made to the KIMS system at the sole discretion of the first respondent without reference to all the players in the presidential election contest? Be that as it may, Mr. Nyamodi persistently argued that the conduct by the first and second respondents, to wit, of declaring results solely based on Forms 34B without reference to Forms 34A, of not scanning all Forms 34A and simultaneously transmitting them to the NTC, of configuring Form 34C to exclude Form 34A tally and only include the Forms 34B tally, of introducing the language of statistics as opposed to results, that all these actions were necessitated, nay, required by the decision of the Court of Appeal in the minor KI decision. We were, on our part, at pains to understand how the Court of Appeal decision in that case could have provided a judicial justification for the conduct of the first and second respondents. The Attorney General, appearing as amicus curiae, having been so admitted, and despite having been clearly restrained from submitting on the so-called impact of the minor KI decision, also appeared to suggest in his closing remarks that somehow the appellate court's decision in that case had changed the landscape of the conduct of elections in this country. In the above context, we reiterate that the main questions that this court has to grapple with at this stage are as follows. A, whether the second respondent declared the results of the presidential election before he had received all the results tabulated on Forms 34A from all the polling stations. B, whether all the Forms 34A had been electronically transmitted from the polling stations to the National Tallying Center. We've read the extensively reasoned and powerfully rendered decision by the Court of Appeal in the minor KI case. We find nowhere in that decision where the learned judges of appeal suggested Section 39, subsection 2 and subsection 3 of the Elections Act unconstitutional. The Court of Appeal somehow, for unstated reasons, lent judicial imprimatur to the first and second respondent to either circumvent or simply ignore the provisions of Section 39(1)(c) of the Elections Act. On the contrary, the appellate court's decision was an unstinging reaffirmation, if not a restatement, of the letter and spirit of the constitutional principles embodied in Articles 81, 86, and 138(3)(c) relating to the conduct of elections, and we have shown why that is so. Section 39(1)(c) of the Elections Act, for avoidance of doubt, provides us for purposes of presidential election, the Commission shall electronically transmit in the prescribed form the tabulated results of an election for the president from a polling station to the constituency. To tally and verify the results. The appellate courts are clear made pronouncement with which we are in total agreement. Not to be exposed to any risk of variation or subversion. Given this very clear elucidation of the law regarding the imperative for electronic transmission of results from the polling provided a justification for declaring the results of the election of the president without reference to Form 34A. How was it a basis for the reconfiguration of so as to render Form 34A irrelevant in the final computation of the results? How did the Court of Appeal decision relieve the first respondent from its statutory responsibility of electronically transmitting in the prescribed form the tabulated results of an election for the president from a polling station to the CTC and to the NTC in accordance with Petition 39C of the At the end of the day, neither the first nor the second respondent has offered any plausible response to the question as to whether all forms that 4A had been electronically transmitted to the NTC as required by Section 39(1)(c) of the Elections Act. What remained uncontroverted, however, was the admission by Ezra Chiloba that as of 14th August 2017, 3 days after the